Okay, well, maybe we should start. I was waiting for our organizers, but since you're all here, maybe we should start. And this is our panel on the Supreme Court and the press. And rather than have statements, we're just going to have a conversation throughout our hour. Does anybody here know when we're supposed to stop? Okay, so we go till 2:30? 2:25, okay. 2:45, oh good, okay. So I will briefly introduce people, very briefly, just so you know who they are. So Tony Mauro on the end here, who I've known for many years in the Supreme Court press room, is currently the Supreme Court correspondent for the National Law Journal. He's covered the Supreme Court for 32 years for a variety of organizations. Gannett, USA Today, Legal Times, the National Law Journal, and Supreme Court Insider, a website for which you have to pay, but worth every penny. And next to Tony is another old colleague of mine, David Savage, who covers the court for the LA Times and the Chicago Tribune. He's been a legal reporter in Washington since 1986, has covered every Senate confirmation hearing for all the current justices from Justice Scalia to Elena Kagan, and is the author of a couple of books, including Turning Right, The Making of the Rehnquist Court, published in 1992, and of the revised 2-volume CQ Guide to the U.S. Supreme Court. Actually, I didn't know you had done that. I need to get a hold of that because I have an old one.
They will sell you one.
I'm sure they will. Can't take a hint, can you? My immediate right is Amy Howe, of whom you heard many references in her husband Tom's presentation about SCOTUSblog this morning. Amy is not only the co-founder and current editor of SCOTUSblog, she's also a Supreme Court litigator. She's had a couple of Supreme Court arguments herself, and lectures at Stanford Law School, and teaches a Supreme Court litigation class at Harvard. And to her right is Kim Atkins, who has covered the court for LawyersUSA in Washington since 2007. She writes news stories and legal analysis, as well as the DC Dicta blog, and is a freelance political columnist for the Boston Herald, for which I was once the collar stringer. Yes, so we have that in common. Anyway, what I thought the most useful question to toss out at the beginning is to ask people to reflect on their experiences covering the Affordable Care Act litigation as it made its way to the Supreme Court. This was obviously not just any old case, and a case that presented some special journalistic challenges, not only covering the decision at the end, and I don't mean to dwell on that, and anybody who hasn't read Tom's fascinating 5,000 or 6,000 word exegesis on how mistakes were made and how mistakes were avoided in the coverage of the actual decision, and I commend SCOTUSblog to you for that. We're not going to get into that. But just, you know, it's obvious from the minute the bill passed Congress and was sent to the president that there was going to be litigation over the constitutionality of the Affordable Care Act, so that gave about a 2-year window for everybody to think about it and write about it. So with that, I would just like your thoughts about the challenges that are presented to you, Tony.
Thank you, and it's great to be on this panel, very distinguished colleagues. I have the luxury now of working for a publication that's really mainly for lawyers, so I was able to credibly suggest to my editor that we need several stories about the Tax Injunction Act aspect of the case, which I actually kind of thought was interesting, but I bet David probably would have had a hard time selling that. But it was an incredibly complex case, and I just was able to, we did kind of a full court press, so to speak, on the coverage. We profiled every lawyer who was arguing. We did separate stories on each of the issues that would be, the court would deal with, and So I think it all sort of fit together, and so it was in some ways a uniquely complex thing, but it was just like it was like a major, like a project kind of story where there were many stories that would come out of it, and we just were able to manage it that way.
So for you, given your legal audience, it wasn't so much a special challenge, it's really a special opportunity to be able to stay on one story over an extended period of time and develop some expertise in the issues that it presented, and so it must have been a very satisfying.
It was. When I say, it's a legal audience, but that doesn't mean that all the readers were expert on the Tax Injunction Act or on the Commerce Clause either. So there was, opportunities to educate and to let people know that it wasn't just a big old amorphous challenge to the privacy of individuals or something. It really had to do with specific constitutional provisions.
So let me ask you this. So given that your audience at least would recognize what the Commerce Clause is and would have some sense of, once there was a case called Wickard against Filburn, and then there was a case called Gonzalez against Rage. So the Commerce Clause attack on the ACA was, ridiculous, basically. And maybe you agree with me, maybe you don't, but it was just, countered the entire trajectory of the Commerce Clause within the Supreme Court's jurisprudence. So how did you, if in fact you did, did you write about the core argument, which was Randy Barnett's core Commerce Clause argument, with any, were you able to bring some judgment to it?
Skepticism.
Skepticism, yeah, thank you, that's the word, right. And if so, how do you convey this? You're not, they're not necessarily paying you to be an opinion writer, but I would have thought it's impossible to just write about this as if it was, just any old argument.
I think I probably just relied on the old crutch of, one side says this and one side says the other.
No, don't tell me that.
But,
no.
But you're asking me, I can't even remember, honestly. I should have looked back to that story. But it's always, you do try to give some analogy. I'm sure I would have brought to bear, Wickard versus Filburn and how that obviously colored the case. And I think I probably would have regarded the anti-Commerce Clause arguments with some skepticism, some analysis.
Because, one might say that's the story of this case. In my colleague Jack Balkin's frame, how this idea went from off the wall to on the wall, to getting 5 votes. Not 5 dispositive votes, but 5 votes in the U.S. Supreme Court. So, Kim, you also write for a legal audience.
I do.
So, what was did you have a relevant experience?
It's similar in the fact that I didn't have to spend a great deal of time sort of explaining the Commerce Clause, but I sort of write for multiple audiences. So we have our subscribers who are predominantly lawyers, predominantly litigators, but also transactional lawyers. And then I write a blog that's sort of more, it's open, its audience is everyone, and it's sort of more, the offbeat side of the Supreme Court, and also a bit newsy, when something big, when ACCA was granted, obviously, I wrote something about that. And so you have these 2 different ideas. Some people still, and even among attorneys, had this idea that this case really was sort of about the right to, choose your health care and things like that. And I keep saying, no, it's really this arcane little part of the Constitution that they're figuring out. It's really not that exciting. But the implications were great. And it also wasn't lost on anyone that this was coming down right before a presidential election. So there were these huge political implications too. So I found myself, also writing the analytical pieces, what each side is, what it means, what the impact could be, and then more specialized things for, so for employment lawyers, what should you be advising your clients to do in anticipation of this, and then there are the folks who wanted me to be a predictor from the point that even before cert was granted. What do you think is going to happen? Is it going to go up or is it going to go down? It's like, I don't know. Even my opinion from the oral argument to decision had changed, in that, based in part on, you know, the public perception and what I've been talking to colleagues about and others. So there were so many multiple arguments, and there were always so many moving pieces that the only way really to approach it was to focus on each piece at a time. The analytical piece, the blog pieces, different things that address different points along the way.
So respond, if you will, to Tony's memory of how he covered the Commerce Clause argument, that, you know, let one person say, this is great, and another person say, this is ridiculous. Do you feel yourself operating under the same constraint, or could you inject some skepticism if indeed you felt it? I don't want to project skepticism onto you that you may not have felt, but in your analysis.
It's okay. I thought it was okay to say when arguments weren't exactly slam dunks. You know, I wouldn't go so far as to say, oh, that, you know, argument is ridiculous, but to point to the fact in the story, it's a part of the story that there is a real tension here, and that it's not an easy case. You know, if it were an easy case, it would have been a lot different. The coverage of it would have been a lot different, that it was this uncertainty. And, you know, depending on who, I mean, we're also not just, I mean, we have sources we're turning to, at least I am, I'm turning to authorities who obviously understand all this stuff much, much better than I do.
Not necessarily.
And, well,
right. I wouldn't assume that.
And, you know, also people who have a dog in the fight. So
right.
You have to, you know, give all that context. I feel like, you mentioned this a little bit at lunch, I feel like my number one job at times is giving context. I mean, that's the difference between just the opinions being, you know, posted on the Supreme Court's website and, you know, why are we here? It's giving the context for that situation, and that's what I saw my role as, most of all, letting everybody's voices be heard, but sort of putting the context in there that this is a tough case, there is no real clear, you know, the Commerce Clause argument isn't a slam dunk. This Anti-Injunction Act is like this wacky thing that sort of came in at the last minute. It's like, whoa. And, you know, maybe we'll call this whole thing off and do it again in 2014. I mean, it was all of these different pieces together that you had to kind of paint a big picture for your readers.
So, Amy, is the ACA that kind of puts SCOTUSblog on the map for those who had not encountered it before. What was the number of hits you had on the day of the decision?
On the day of the decision, we had, I think, over 5 million hits from over 1 million unique visitors.
Yes, one of which was certainly me. So,
yes.
So you and your SCOTUSblog colleagues obviously covered everything.
We did. I mean, this was kind of like our Olympics in the sense that this was the blog's biggest day. It was one of the biggest cases in God knows how long, and it wasn't just sort of a really big case. It was the sort of the Supreme Court weighing in on the constitutionality of the president's signature health care program right before the presidential election. And as Tom mentioned this morning, we had started out, you know, with 30 people in the first couple of days of the blog's existence, and over the years had sort of built up. And I remember being incredibly excited in 2008 when the court issued its decision in the gun case, DC versus Heller, and we got about 100,000 hits in a day. And so over time, we had sort of ramped up our technical capabilities. But when Justice Stevens announced, sort of somewhat out of the blue, his retirement in 2010, we crashed. We weren't prepared for the demand, and so we spent a ton of time, getting ready for the Olympics substantively in terms of, having these huge team meetings where we'd figure out who was going to cover what and when. But we, really, I felt like one of our biggest challenges and the issue that was keeping me up at 4 o'clock in the morning the day of the decision was whether or not we were going to crash. Because it doesn't matter how good your substance is if it's the tree falls in the forest. If we have this great substance out there and there's no one who's able to read it because we have crashed, it doesn't really do us a lot of good. And so I can't actually take any credit for the fact that we didn't crash, notwithstanding all of the sort of worry that I gave to it. We had Tom and Max Mallory, who's one of our blog managers, put an amazing amount of time and money into making sure that we didn't crash. And we had 6 different servers in different states, and I don't actually still understand why that was important, but apparently it worked. And so people asked me this was sort of our moment, 15 minutes of fame, literally. And when people ask me sort of what was going on sort of through your mind at the point that the court issued its decision, and my response, and I think Max's response, and Callie Borkowski, our blog's manager, would have been a tremendous sense of relief. Like, okay, we have not crashed. Like, everything else that happens from here on out is gravy, and Tom and Lyle and Kevin Russell, our law partner, who have the actual copies of the opinions, like, they now need to figure out what it says, but we're not going to crash.
So going back for the preceding 2 years,
yes,
as obviously anybody could see, this was eventually going to reach the Supreme Court. What did you do and say about the Affordable Care Act in all those preliminaries?
Sure. I mean, we started out, we ran an online, you know, we'd spent a ton of time covering it, starting out, you know, particularly when it reached the courts of appeals, and then the courts of appeals issued their decisions, and it kept getting closer and closer, and we really covered every aspect of it, from the courts of appeals decisions to the Kagan and Thomas recusals, and we had online symposia in, I guess it would have been the summer of 2011, when it was obvious that, you know, different courts of appeals had reached different results. The 11th Circuit had struck it down by then, and that it was completely obvious that it was coming to the court, and it was a real case, and there were real Commerce Clause arguments. And, you know, our challenge, both sort of in the years leading up to the decision and then on the day of the decision itself, I mean, it's a fun challenge to have. We have a fairly broad audience. We write for lawyers and law professors, and then we also write for members of the general public who aren't lawyers but are very interested in what's going on. And we're very fortunate that we have, you know, we are not subject to sort of, you know, the whims of editors who tell you, you know, you've got X number of column inches. And so we, you know, just threw it all at the case. And so, you know, leading up to the decision and in the day of the decision, we had Lyle and some of the other lawyers covering really the nitty-gritty analysis. We had reactions from lawyers and law professors who followed the case closely. And then, you know, I had a number of plain English columns really trying to break down in relatively simple terms, you know, without references to Wickard versus Filburn or anything else, to what was going on for the general public. And it did feel like there were a lot of moving parts. Some of the pre-writing that I did in the days after the decision felt to me like one of these choose your own adventure novels that my kids like to read. And so you've got, like, you've got the Anti-Injunction Act, and then you've got the mandate, and then you've got to move on to severability if the mandate gets struck down, and then depending on the severability, what about Medicaid? I did not ever write anything that assumed that the court had ruled that the Anti-Injunction Act applied. I was pretty confident that that was not going to happen. But, you know, we knew that the decision was going to be long and complicated, and so it was just a question of trying to break it down.
So you mentioned the Court of Appeals decisions, and I'll turn this over to David now, but if I were critiquing the sort of general interest media coverage of the 2 years, I would be very critical of the coverage of the Court of Appeals activity, because the 11th Circuit came first, and I mean first the district judge in Florida, affirmed by the 11th Circuit, and that made big news. You know, federal court strikes down the Affordable Care Act. And then when the 6th Circuit upheld it in that fascinating opinion by Jeff Sutton, and the DC Circuit upheld it in that fascinating opinion by Lawrence Silberman, and the 4th Circuit found it non-justiciable, these were all really interesting things that were going to have some bearing on the outcome. Those hardly got a mention in the general media. So what people who were trying to follow it would have come away with was, wow, you know, this is very sketchy. The lower court seems to think it's not constitutional. Did you get involved in that part of the run-up to the Supreme Court?
I did write about all of them, but I do think that the one that I remember being on the front page was the 11th Circuit decision striking it down.
And the others were really man bites dog. I mean, Jeffrey Sutton and Lawrence Silberman voting to uphold it was really much more indicative than, you know, a hand-picked Republican district judge in a district where the plaintiffs went because they knew they had his sympathies, you know, striking it down like, and, you know, really was kind of a big so what, but nobody treated it that way.
This case reminds me of the sort of thought we've had, and it's been mentioned at this conference, is whether the Supreme Court's a court of law or it's a political court. I mean, isn't that what everybody was really thinking about in this case? I think day to day, year to year, there are a lot of cases they decide where precedent and the law does pretty much guide the outcome. And then every so often there's one that comes along. You and I remember the Bush versus Gore sitting in the cafeteria talking about it. You couldn't find a law professor in the country who had thought that they'd take that case. And you couldn't have found anybody who said they're going to reverse on equal protection grounds. I mean, come on. I mean, Scalia and Rehnquist had never voted for an equal protection claim in any circumstance. And the Affordable Care Act was one of those great cases. You know, week to week, I always find my job writing for a general audience is, first of all, trying to write simple English. Judge Posner said last night, you know, that he asked the lawyers in a complicated case, please explain this to me in one-syllable words. And I was thinking, boy, if you got to explain it to Judge Posner in one-syllable words, imagine what I have to do for a newspaper audience. So there's that question of sort of writing, explaining. And then I also find another job that I have is trying to explain why cases are significant, and lawyers sometimes are helpful on that, sometimes not. But on the Affordable Care Act, this is the one example that everybody in the country knew this is a big deal and it's highly partisan. I can't think of an example like that where a major reform is passed by a Democratic Congress, all Democrats, signed by a Democratic president, opposed by every Republican across the board, and every Republican running for president says, hey, I will repeal that. That's the one thing you can count on me. I will repeal. You know, you couldn't run for. So that's about as partisan and political as you get. So if you're the court reporter, you think, well, are they going to be guided by their Commerce Clause precedents? Or perhaps not. And you saw how this played out. I mean, it was almost for a while, if you got a conservative appeals court, a few exceptions, you'd get a Republican district judge, they'd strike down the law. And so I thought this was a sort of a great, interesting test, and we didn't know the outcome. Is the Supreme Court going to act like a court, or are the 5 Republican appointees going to vote down the 4 Democratic appointees? I wrote some stories on the Commerce Clause. I wrote about Scalia's opinion in the Raich case, for example. Do you know that, the medical marijuana case? I mean, my goodness, here's a situation where medical marijuana is legal in California. Angel Raich grows marijuana in her backyard to grow at home for use at home. She doesn't enter commerce, she doesn't buy, she doesn't sell. How does the federal commerce power reach Angel Raich's backyard? Well, it turns out Justice Scalia says, hey, if you want to regulate the national market in marijuana, the only way to do it is regulate the whole market, even for the people. Well, because that's exactly what the Obama administration said about health insurance. The only way to regulate the national market in health insurance is to regulate the whole market and require the freeloaders to either participate or pay a tax. Now, you might have thought if you were a lawyer and a law professor, Scalia will be on the side of those voting to uphold the law. And Linda and I have talked about this. I wrote a story that sort of said there's a whole lot of precedent on the side of if it's economic, it involves national markets, Congress can regulate it. That's what the Commerce Clause is about. On the other hand, I didn't want to make a total fool of myself. One of our colleagues did write a story about how Justice Scalia would be really the swing vote, the deciding vote, based on his precedents. And I thought, oh my God, I don't want to write that. I'll look like a fool. Because Scalia's not going to, So anyway, I thought that was such a fascinating case, because in the end, you didn't know whether law was going to prevail or politics were going to prevail. And I think John Roberts didn't want to be on the side of striking down that law entirely. It's hard to call yourself a modest umpire and strike down a major law. So he managed to join the conservatives on the big issues, the commerce and the spending power, and nonetheless uphold the law. And who would have guessed that at the beginning?
So you're the only one of the 4 on this panel who writes explicitly for a non-law audience. Not that some lawyers don't read your stuff, obviously, but just remembering from my own experience back when the court was decided Immigration and Naturalization Service against Chadha, huge administrative law case that invalidated the legislative veto. I was told by the executive editor of the New York Times that I could not use the phrase legislative veto in my story because that was jargon. So it was like the court today invalidated the, that which dare not speak its name. So, so did you have any similar experiences in this?
And Linda knows, when the case was moving along, I said I could write a couple stories about it, and I got back one admonition saying the lawyers say they don't want a story on the Commerce Clause. And I said, come on.
The editors say. You said the lawyers.
Oh, I'm sorry. Yes, the people that I work for, the editors said, we don't want a story on the Commerce Clause. And I thought, well, how did, like writing about baseball, and don't give us the guy's batting average or, so I wrote about what the court had done on similar cases, but they actually didn't want a story on, I could sort of make fun of them as being, not very thoughtful or deep people, but I also detect in those conversations, sometimes on the phone with people in Los Angeles, they have a version of the cynicism or skepticism that I was alluding to earlier, which is they don't think they're going to decide it on the Commerce Clause. They think they're going to decide it on a sort of political, we're going to strike down Obama's law or we're going to uphold Obama's law. But I worked around it. I wrote about the Commerce Clause without saying I'm giving you a story on the Commerce Clause.
Right. So moving on, Kim, you said something that raises a question that I wanted to get into here, growing out of our first panel this morning on technology, which is now that anybody can read a Supreme Court opinion in real time on the court's website, anybody can read about it on SCOTUSblog, anybody can pull down the briefs, the transcript of the argument, the audio of the argument. So what is the added value that journalists bring to this beat these days?
Journalists bring a lot of added value. No, I'm kidding. I'm just trying to keep myself employed.
Yeah, we're unanimous on that.
And stipulate that.
Very important job. Well, yes, you do have this information about the cases and stuff, the decisions anyway, that is made readily available. And recently, transcripts come out much faster. And when I started, I think it took at least a day for a transcript to be ready, and then it was by the end of that day, and now it's within like a half hour. It's up on the website already. And there is an increase in information. But I don't think a lot of people, lawyers included, are spending an awful lot of time reading oral argument transcripts or even opinions in cases that could affect them a lot of times. I mean, I feel that, that context is important even within the legal community. I mean, I find myself a lot of times writing a lot about, immigration law and how that affects employment law, how that affects criminal lawyers, how that affects all these different people. And it's sort of like, oh, okay, real. This is something that I wasn't putting all the pieces together on. So, I mean, I think there's always room for that context. There's also the fact that, I spend an awful lot of time in the courtroom covering oral arguments. Sometimes if it's cases, it's not always the healthcare case, Sometimes if it's an ERISA case, I'm the only journalist in the bed. It's like me and the sketch artist are sitting here watching this case. And, it's even though there's all these advances in technology, to this day, no electronic devices are allowed in that room. So the only way until, even with the transcript, a cold transcript reads very differently than what actually happens in that courtroom. And I feel that it is important to give that context about what's going on and about what the justices are doing and how they're engaged and how, I try to use adjectives that really describe when Kennedy is really honing in on something at oral argument. This is important, people. This is an important point. This is what's going to come back and make the difference in this case. So I think it is an important role to play. Also, readers all readers, lawyers and otherwise, want news now, and they want it in the way that they like it. And one of the reasons I was hired at LawyersUSA was that they wanted to expand the way they wanted to cover the Supreme Court. They wanted me to start a blog. They wanted to start using social media. They wanted to start covering the court in a way that they hadn't done before and that necessarily hadn't been done a lot otherwise. I mean, SCOTUSblog was in existence, and so I had to figure out, okay, I can't reproduce that because that's already there and it's great. So you have to look for a different way to do it that really touches an audience, and have been fairly successful with DC Dicta with that. But again, it's just the context and the added value that somebody who is there, who is seeing it happen, and who can understand it a little bit, or at least call on experts to explain it to them, to digest it and give it to the readers.
David, you've been at this a long time, so how has the technology changed, for better or worse, your day-to-day life on the beat?
Well, it's sped up the pace of everything. I was telling Tony that, like on the day of the Affordable Care Act case, I had done 4 or 5 possible decisions, including one. I insisted on saying that they could uphold it on the tax power. But in the old days, when you and I were doing it in the 80s and 90s, I could go upstairs and listen to the opinions and listen to the dissent. Now, within 15 minutes, I start writing a story for our website. So it's sped up the pace. You have to be prepared. There's always a great opportunity to make a fool of yourself when you're, writing quickly with a decision you haven't even finished reading yet. On the other hand, the other part of the technology is like the blog, the SCOTUSblog and all that. It's so much easier to, we used to spend a lot of time up there, standing there, going through the paper briefs and photocopying, and you remember how much time you'd spend, like, for example, with cert petitions, just trying to read them. Now it's the technology.
And SCOTUSblog reads them for you.
Yes, they read them for me, and they decide which ones are worthwhile. And it's also so much easier to get a hold of lawyers. So I think everything about it has sped up, and I think 90% of it's for the better.
When I first started covering the court in '78, there was a copying machine in the press room, and it could only copy a single sheet. It couldn't copy, you had to feed a sheet into it. So it couldn't copy, like a cert petition. Or it was just the weirdest thing. This was like not, Pony Express days.
Right.
And
slightly beyond.
Yeah. So certainly the court was, slow to change, but it did change. But, talking about the cert petition, so back in the old days, before SCOTUSblog highlighted for us the petitions to watch off of every conference list, people actually had to make their own judgments about that. And so you had to decide, you had to take the conference list, which is not a public document, but is one of the few non-public documents that the court public information apparatus makes available to the press. So you know all the cases that are going to go to conference on that given day, and you look at them. And you have to say to yourself, which of these might be granted, which grants might make news, which will be denied, which denials might make news. Sometimes if they deny all the DOMA cases after the conference of November 30th, which they won't, but if they did, that would be news. And you had to make your own judgments. And we used to talk a lot about this and kind of compare notes because it's not a competitive beat in that sense. You all get the same information at the same time.
We were more sociable then.
Much more sociable.
We hung around the press room. That's
much
right.
more sociable. Yeah. So SCOTUSblog comes along. We ruined all that for you. And, social life in the Supreme Court press corps disappeared because nobody physically had to be there because the petitions are online. No thanks to the court. The court.
Lyle has to be there.
Lyle has to be, right, but he's working too hard to socialize. But, Jerry Goldman mentioned the inadequacies of the court's website, one of which is they never, at any time in the decisional process, post a cert petition. They'll post the pleadings on the merits, but the only way to get the petition for cert and the op cert is SCOTUSblog, so that's bad for the Supreme Court website, but it's good for everybody in the privacy of their own home can read all these cert petitions and never have to come to court. So that's really been just a change in the social dynamic of the beat. By the time I left there 4.5 years ago, I found it kind of a lonely place because I really, because I was still doing that as a matter of principle, reading all the cert petitions. But since nobody...
one thing, Linda and I used to write stories that would come out in the newspapers the next day, right? Now, if something happens at 10 o'clock on Tuesday and you're writing it, people think Wednesday, that's old news. I mean, we read everything we wanted to read about that yesterday. So I almost get the feeling if you don't get something up by 12 or 1 o'clock and people have it online during the middle of the day. So it really has changed very much how we do the job. And I can't judge whether the coverage is better or worse. I mean, I was telling Tony in the cab, I did a radio program on the day of the Arizona immigration case, do you remember? And then the host on the Talk of the Nation said, well, did President Obama's DREAM Act come up in the delivery? And I said, no, it didn't. Well, it turned out that was part of Scalia's dissent, which I didn't hear upstairs. I went down, got Kennedy's majority opinion, wrote a story about it, and did it. But, you know, I felt like a fool. I called him the next day and said, sorry, I didn't pay attention to dissent, but he had heard it on the radio. So some ways I think we do really well racing, but I'm also aware of the fact that you lose a little bit. You and I used to go back on the Metro and talk about what they said. We didn't have to decide till 2 or 3 in the afternoon what we were going to say as the lead of the story. Now I find I've got 15 minutes to decide.
Yeah, so in terms of the added value that the journalist brings to this, so in 15 minutes, you know, it's hard to say that it's more than a headline service, right? So
it's more than a headline service.
It's hard to say that. You had to work hard to say that. So, you know, I mean, is there an occasion, or without working 22 hours a day, you know, to then go back and do the analytical stuff that was easier to do when you didn't have to be shoveling it out at 10:30 in the morning?
Well, let somebody else answer that. I find it hard to judge whether we're doing as good a job now, just faster, or whether we're moving so fast we're losing the nuance or perspective. But what do you think?
I agree. I think there is still room and time for a good analysis and you know, bringing in historic, you know, things you remember from a case that was argued 20 years ago, which I still occasionally do remember, and to you know, give some context. But it is really remarkable. The immediacy it's not just with breaking news on a decision that just came down, but even on personalities and other. I've been writing since 1986 a column called Courtside about the, you know, offbeat things or off the bench things that the justices do. And if I heard a tidbit, I could just sort of stick it in my back pocket and get around to writing about it 2 weeks later. And now, if I don't write it, you know, immediately, it's somebody else's guy. On election day, there was a blog item about Justice Sotomayor voting without having to wait in line at a D.C. Polling place, and somebody had taken a picture of her with a security guard bypassing the line, and that was something that was on there within hours of when it happened. So that's like old news by the time I could have gotten around to it in the old days. And so it really is a remarkable change. And I think overall, I think it is a good thing. I think it is the diversity of voices and eyes and ears covering the court is tremendous, and I think it's all to the good. Even though there are fewer of us journalistic sages or whatever you want to call it who have been there for a long time. I think it's all.
I was going to say we count on you to do the sober second thought a week later.
That's right.
I mean, you know, certainly now, I mean, just, you know, from my own perspective, being in the classroom and teaching about the court, the online resources make a huge difference. I mean, all my students are, I told Jerry, addicted to OYA, and of course, you know, I assume they check SCOTUSblog several times a day. You know, the other day we had a class on the art of oral argument, and I said, you know, go on the court's website and pull down the transcripts in Fisher and in Jardine's, the dog sniff case, and, you know, it's there on the website, and then we're going to analyze what were the best arguments, what were the worst arguments, what was the worst answer to a question, what answer would you have given to that question, and so on. And it just makes it, you know, much easier, because until rather recently it took not just a day, but 2 weeks, 2 or 3 weeks to get a transcript, Of course, it was not electronic, it was hard copy, and it didn't identify the name of the justices. So, you know, under the conceit, oh, you don't even remember that. So the conceit was, you know, the court speaks, and it doesn't matter whether it's Justice Scalia or Justice Ginsburg, the court speaks. And, you know, it was late in the Rehnquist years. Chief Justice Rehnquist relented on that.
Remember, we used to ask him about it and say, well, why do you do that? And he said, well, I don't know the reason, but that was the rule when I got here, and so I don't see any need to change it.
Yeah.
He couldn't even think up the reason for doing it.
And they do that for so many times. I mean, talking about the court and technology, one thing that at least they have started doing this year, they used to release orders and opinions or have orders released at the start of oral arguments right at 10 o'clock, which leaves you, if there's a big grant, do you cover the grant? Do you cover the oral argument? And now they have, you know, we've been so grateful that they've started releasing them at the orders at 9:30 instead of at 10, which makes a huge difference.
It does. It sounds ridiculous.
Actually, but it sounds ridiculous,
Yeah.
and there is no reason not to do it other than the fact that that is the way that they have always done it.
But I think that's a matter of the court throwing us a bone every year or so to keep us from the big goal, which is cameras in the Supreme Court. And they say, well, we're doing all these things. Why do you need that? And of course you need that. It's the Affordable Care Act. Any case you want to think about, and it's not just educational value. It's just the you know, it's almost transparency for transparency's sake. That is part of the public institution, and it ought to be there.
Tony and I had this strange experience when the spring that Justice Souter quit. I don't know that you were there, Linda. He went over to speak at some group in D.C. and Souter didn't speak often, so some of us went over to hear him. And it was
the I was there. Yeah, it was a great speech too.
Yeah, and he talked about this was getting on the importance of civic education, and he talked about going with his mom and dad to was it once a month or once the annual hearing,
town meeting,
the town council, and he gave this sort of moving talk about how, as a little boy, he got to sit and watch the members of the town council and all the officials. There'd be the fire chief and the guy who was in charge of roads and the treasurer, and he said, I basically learned what I learned about government, separation of powers and all that, by getting to see it in person. And Tony and I were sitting there thinking, wait a minute. And then he was going to go out and he was going to give the rest of give these speeches about civic education, and young people don't appreciate it. He could have allowed cameras in the court.
Over his dead body.
Right. He was one of the most zealous defenders of, we're not going to let cameras in this court so young people out there can watch how our government really works. And I thought, you know, come on. It's like it never occurred to him that he actually could have done something on that score while he was a member of the Supreme Court.
Well, I mean, they even with the Affordable Care Act and Arizona, they acted like they were doing this tremendous favor by releasing the audio the same day. You know, usually you have to wait. They release the transcripts the same day, but you have to wait until Friday to get the audio.
Which is better than before you had to wait to the end of the term.
But
yeah.
You know, it's there. It's actually not that difficult.
Right.
So the audio question, maybe we'll conclude with this observation and take questions or conversations. So the same day audio is obviously a rather freighted subject in the mind of Chief Justice Roberts, because the court under Chief Justice Rehnquist had started occasionally on big cases issuing, putting out same day audio. Was Bush against Gore the very first?
I think so.
Yeah.
Palm Beach County was the first.
Right, I mean, the Bush against Gore, thank you, the Bush against Gore cases. And it had become a fairly routine expectation for the big cases of the term, the handful of big cases. And then there was the audio in the Section 5 voting rights case, Namudno, in the spring of 2009. And that was really interesting because I wasn't in the courtroom. I was at Yale already, and I listened to that argument in the company of Yale's major election law expert, Heather Gergen. And we sat there listening to it, and at a certain point we turned to each other, and we said, oh my God, they're really going to do it. They're really going to strike down Section 5. It was clear from the tone of the argument, from what was coming from Justice Scalia, Justice Kennedy, Chief Justice Roberts, and then, of course, we know that they pulled back from the brink and are going to wait until this term. So, But they pulled back from the brink in such a, implausible, ridiculous way that I always had in the back of my mind the question as to whether, every voting rights and civil rights person in the country, having heard that audio, came to the same conclusion, and there was quite a ruckus, in the commentariat that the court was about to overturn Section 5, whether that feedback loop is what gave them cold feet at the end of the term, and whether that fact caused them the next term to not do any audio. Well, they did, I guess they did, Citizens United, they did, because
but there
they
were,
sort of had.
There were a couple of periods when there was
big gaps, and whether they said to themselves, or the Chief Justice said to himself, we don't need this. We don't need this source, just, so I don't know. Did other people, did that occur to anybody else?
Well, I mean, healthcare would sort of play into that same storyline, certainly. After everyone heard the oral argument, it sounded like the mandate was going down, and then there was all of this pushback that was supposedly aimed at getting Kennedy or Roberts to switch votes, and, Jan Crawford's story says the Chief Justice did switch.
Well, I think I don't think we needed Jan to tell us that. I think from the
she confirmed
from the structure of the opinion. So do people have questions, or Dan?
I was going to ask about Jan Crawford's reporting, because it's a different style from the kind that all of you are describing. I mean, you're very content focused, and it's not the kind of reporting that is done if people are looking at politics, where they try to get behind the scene. And I mean, there's the Brethren, which is that was behind the scene, but there's rarely news reporting, and that's got to be because I guess people aren't trying. But I mean, here Crawford did this, and so I'm wondering what you think of that, and why we don't see more of that, and who was your source?
So,
which one?
I'm happy to engage in this, but I'll give other people a chance first.
You're right, that kind of reporting isn't really done very much. And I guess it isn't tried very much, because I guess, this is a beat where you get accustomed to never really talking to the people you cover. That has changed to a degree in the last year. The justices in general are more accessible.
But they never really tell you what you want to know.
No, they don't. They won't say, I really duked it out with Scalia on this, on the Commerce Clause. They're not going to tell you that. I mean, although you're right, somebody told Jan that, so maybe I got to.
Do you think somebody from the court told her? I don't think so.
I don't know. I really don't.
There's staff members.
Well, how about wives?
Yes.
How about two wives?
How about spouses?
Wives.
Spouses.
Of sitting justices.
You remember Clarence Thomas's wife had gone out sort of campaigning against Obamacare, and so I think that's a good. So in other words, it didn't have to be one of the justices to say somebody had direct knowledge.
She never claimed. If you look at her story, she never claimed that her source was inside the court. She claimed her source had direct knowledge. She had two sources with, quote, direct knowledge. That's some kind of term of art. Sorry?
Did you ever try to get someone to believe something?
I've tried many times to get.
And then she gave up.
No, I mean, not to make light of it. I mean, I've tried to reconstruct the healthcare law by having very civil conversations with various members of the court, with whom I have very civil relations, and they haven't told me anything.
I seem to remember you did Planned Parenthood versus Casey. You had a pretty inside, behind-the-scenes look. Maybe you won't reveal your sources, but
well, I'm glad to. I had done this book that came out in the spring of '92, inappropriately timed, about the courts that are turning more conservative, and I think that the Casey case came down in June, and during the summer and in the fall, I went to see Justice Scalia, and I went to see Justice Souter and Kennedy, and so I was interested in what happened. Remember, we were all sort of surprised. And Souter sat there and said, well, you know, and he sort of told me about what they had done. He said, I sat here sort of drafting my portion, and let me see, he said, Sandra had said she was undue burden, you know, she was not going to vote to overturn Roe, and Souter said that's basically where I was, and then after I talked to Sandra about it, Tony came and said, I think I'm with the three, with, you know, you two. So they started to draft this joint, what became a joint concurring opinion, and Rehnquist and Scalia didn't know. Blackmun and Stevens didn't know till later, I think. But I think it was possible to do that if you've. I think Linda they would talk to her. As I say, had just written this book. I think Jan is very. The conservatives have a very high regard for her. She wrote this, I think, laughable piece about Clarence Thomas being the sort of intellectual leader that ran in the Wall Street Journal at some point, and so Thomas would always cite this as Jan Crawford showed that I was, as soon as I got here, I was an intellectual force, and I thought it's okay. And so they were very, I think Jan is one person who could check with Mrs. Thomas or Sam Alito or Mrs. Alito or whatever and get a pretty good reading.
I have a somewhat different view of that, but I mean, I don't know, but I think I'd be truly surprised if it had come from anybody directly connected to the court. I think there's a group of conservative lawyers who kind of circle the court, and a kind of a network. And if you track, for instance, over Memorial Day weekend, all of a sudden, these right-wing pundits like George Will and Ramesh Ponnuru, what's his name, started coming out with kind of agitated columns about, oh my God, the Chief Justice may be going soft on health care. So something was out there. Right. You know, and I actually wrote about it in my column at the time. I said, something's happening. And when the decision came down that day, I wrote a column for the Times. I said, there's evidence in the opinion that Chief Justice changed his vote sometime in the decisional process. You didn't need a leak. You didn't need a source for that. So I think, you know, anybody kind of trolling around that had good relations with that group of lawyers, something was out there. And, you know, she was able to pick it up. I'd be shocked if it was closer to the court than that. Yeah.
Yeah, hi, Steve Heyman from Chicago. It seems to me one of the biggest kinds of value added is the accounts of the oral arguments where you say, you know, it looks like the court's going to do this. And sorry, I wanted to ask you to talk about that a little bit. You know, how easy do you find it to read through the justices and to figure out what direction they're going in? How do you do it? Is this like chicken sexing? Is it something more articulable? And how accurate do you find that your predictions end up being?
Yeah, the answer is it depends. I found, I was talking a little bit earlier casually about, you know, what do people want to know? Do they want you to make an opinion? I'm like, no, what my readers want is for me to predict. And I was really uncomfortable in the beginning, you know, doing that, because it's like, who am I to say what the Supreme Court's going to do? I don't know. And, you know, since law school, we were taught that oral arguments are a terrible predictor of what the actual opinion might be. You have those who, you know, want to play devil's advocate, and they may push harder on the side that they're more inclined to lean on to sort of test their own judgment. But you know, it depends on the case and it depends on the justice. Some justices, it obviously, you know, Justice Scalia may as well wear a T-shirt that says, you know, don't, you know, talk to me about messing with my framers' intent of the Constitution. But and he's very, I mean, Scalia gets to the point sometimes, which I find is really interesting, is he'll help the side that he's leaning toward. He'll help them advocate. And when they're not making their case well enough, he's, don't you mean to say that blah, 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 and he'll like make the case for them, which, you know, so obviously he's easy to read. There are others who are not. you know, and you may get signs, like I said, when Kennedy presses on an issue, you may not know yet which side he's leaning on, but you know what he finds really important. You know, then I'll write the story that says this such and such case may turn on the issue of blah, blah, blah. During oral arguments, Kennedy, you know, pressed the attorney about this. So it's not always easy. It was pointed out to me during this consortium, which I hadn't considered before, that if I'm wrong, who cares? So maybe I'll be a little more fearless with it now, because not a lot of people hold you accountable and say, hey, you said it was going this other way. But in a case of healthcare law, I didn't do a ton of predicting because it was so complicated and so much was at stake. But I emailed my editor after I got back to my office covering oral arguments and said, you know, apparently I said I think it was going to be upheld narrowly. And then during the course of the next couple months before the decision came down, I was like, oh, it's going down. It's like, it's done. And we need to really plan on how we cover, you know, once it goes down. And she sends me back the email on the morning before the decision is handed out that, oh, you said it was going to be upheld. And I said, oh. And there it was. And once the decision came out, I'm like, of course I said that. But it can be tough. It can be really difficult. But people really do want you to do it.
And it seems it's been my experience that the more sort of moving parts there are in an oral argument, the harder it is to predict. And I think the Arizona case last term was a great example. You know, there were 4 different provisions of SB 1070 that were at issue, and they spent almost the entire time talking about one of them, the Show Me Your Papers provision, and it did not look good for the United States. But they didn't spend really any time talking about the other 3 provisions. And so then the decision came out and the U.S. lost for the time being, at least, on Show Me Your Papers, but won on all 3 other grounds. And then, you know, the mandate argument, we spent all the time focusing on the Commerce Clause, and we had this tiny little mention of the taxing power at the end. And there's only so much you can go on. And some of the sort of simpler, you know, even if they're sort of high-profile cases, like, you know, Shelby County, you know, there aren't quite as many moving parts, and it'll be easier to just sort of count the votes on the issue.
No, there's a few in that.
Yeah.
But anyway, you guys?
I think there's a good chunk of cases where you can come away and think, I know which way the wind is blowing, and you can venture a guess saying, you know, they're sharply critical of such and such a side. The problem I sometimes have is that Justice Scalia looms so large in oral arguments that sometimes I think there's a trend in one direction, then I go look at my notes and I think, oh, it's just Scalia. And he's only 1 vote. But
we'd be hard up for quotes if it were not for him.
that's true.
I'm glad you like those stories because, I think a lot of people are writing those stories more than used to be, partly because of the web during the day. I think it's also something that people have been covering the court for a while can do and do reasonably well. And you see people come in from out of town. It used to be the case more so than now, where reporters would come in from out of town and they'd almost always write a story that says, one side said this and the other side said that. In other words, it didn't really advance the story other than what you already knew in the briefs. But if you've listened to them for a while and can count the 9, you know, or count to 5, you can pretty much get a sense in most of the cases, so long as you're willing to forgive the occasional error. Like, you know, I mean, I thought, for example, in the healthcare case, after a couple of days, I thought, my God, it really looks like all 5 of them are inclined to strike down the mandate. And I went to the Medicaid argument, and I thought, you know, Kennedy at one point said the states have no realistic choice. They have no choice in this matter. And it looked like they were going to, you know, reverse on the spending power. So I remember writing stories saying it sure sounds like they're going to, turned out not to be correct, but I still think it sounded that way that day because, as we've said, if there was a John Roberts switch, it came a few weeks later.
But I just, in terms of the oral argument story, so if you look at the various kinds of, you know, journalistic interventions in covering the court, so a case is granted, argument, the case is decided, a decision is analyzed. So that, the argument story is really the hardest, I think. Not so much because of its predictive nature, because I actually did not predict unless it was very clear to me, but just imposing coherence on an event that does not unfold in a linear way. So as you know, there's no time during the argument where you know, the facts of the case, such as they are laid out. The justices jump right in. I mean, my practice was never to even bother going to an argument that I hadn't read the briefs and prepared on it. And, you know, some chunk of the time I would think I'd wandered into the wrong argument because they're driving it down a road where they wanted to go, but it's not necessarily. So I remember one time coming back from some particularly tough, incoherent argument, and at that time I sat next to a guy in the office who covered national security. And he said to me, I wish I had an easy job like yours. You just sit in the courtroom, you take transcription, you come back and write it. I said, I'm going to throw you out the window. Your job is the easy one. So, Nancy.
Well, this is going to make me very unpopular before a group of journalists, but I'm actually against cameras in the Supreme Court. And so I want to press you on the two arguments that I worry most about. One is the way it changes people's behavior, just the Justice Scalia looming large problem. And now the one that your panel has brought out with emphasis on oral argument and prediction rather than on the opinion and the decision, and focusing on quirks, you know, the broccoli, let that stand for all of healthcare, and the way we reduce the complexity of a case to a particular image or a comparison. And so I worry about the court from that perspective, and that the discourse will be lowered rather than that everyone will be educated and raised up. So your responses.
I actually agree with you, but I'm just the moderator.
Go ahead.
I said, Tony, you're Mr. Cameron's in the court.
Oh, well, I think everything you say might be true, but I think it's that the court doesn't get to decide that the cost-benefit analysis. I mean, it does. In reality, they do kick cameras out because they still can, but I don't think they should be entitled to that sort of discretion about what I think is an obvious public good, a transparency, and no matter what impact it has, I think it's just good in itself. And I think the court, you know, there may be some initial problems with or initial shifts in dynamic, but they'll get used to it. I mean, this is modern day America.
And how many hours of C-SPAN coverage of various branches of the federal government are aired, and who watches that? I mean, we still have folks, yes, and I do too, but we still have, you know, an active press corps in all of those places, and we still have the function being served. I mean, at first I was against it too, because I thought it would put me out of a job, but the more I thought about it, and the more that I think that I don't think that most people will just want to watch an hour of this case. And part of the problem that we're talking about is happening anyway, right after, you know, during the healthcare oral argument, there was that Solicitor General Don Verrilli cough heard around the world, and it sort of stood for this, oh, he choked, literally, you know. And
which set the cost of cameras in the courtroom back like another 20 years.
Exactly. It's like, well, it's not exactly how it happened, but I mean, we still have sort of those problems anyway. I think that it's much ado about nothing once it comes out, because it is hours of really long, at times mundane legal discussions that.
But of course, it wouldn't be just C-SPAN. It would be the networks picking up the C-SPAN clip of the little quirky moment.
Right.
That's more the issue.
Well, that's what I mean, but that's available now in Congress. It's available now every place else.
Right.
And
Jared.
I mean, okay.
Just a small snippet of evidence to support Nancy's position. There's a function on the OYA site that we don't promote. It allows individuals to create clips of oral argument, just a little segment. It's also available in the apps that we produce. And with the ACA case, the principal clip, by far, thousands of clips of the broccoli episode. So it suggests to me that if you had cameras in the courtroom, that would be the kind of snippet that would become the newsworthy moment when there are so much more larger concerns in that case rather than the broccoli comment. and would encourage the kind of behavior that would create more.
Can I talk about the behavior point for a second? I mean, to the extent that you're talking about the justices' behavior, well, that's their problem. And they can't use like the fact that we're going to behave poorly as an excuse not to have cameras in the courtroom. And from the advocate's perspective, I mean, I think at first it would be an extraordinarily foolish thing as an advocate to try and come out with sound bites that are tailored to cameras, to waste your client's time and sort of gain the justice's enmity by, prepping the sound bites that, the justices hate jokes by the advocates, They get to make the jokes, we don't. I think...
That's funny.
Oh, thank you. That's very nice of you to say. And just as far, that also assumes the ability to get your sound bites out. I mean, somebody like Paul Clement, who would not be necessarily foolish enough to try and work in the sound bites, is able to control the flow of the oral argument and work in his points that he wants to make in the course of responding to the justice's questions. But the rest of us aren't really quite as good at doing that. And so you're kind of the justice's ping pong ball, and you answer their questions. You don't come out with your own sound bites.
What's the other setback they always go is they all go through confirmation hearings on television for a week. If you talk to Elena Kagan before and after, they go over to the Senate hearing and they think all these gas bags talk for TV, and they have such a bad impression of what TV coverage does. You remember Justice Stevens used to say he was the last justice to be confirmed in a process where there was no TV in the Senate Judiciary Committee, and it was a much more serious, sober, where television, they think, completely changes the process. And I don't know whether they're right or wrong, but that is their view, and a lot of it comes from their own experience in the confirmation hearings.
Jason.
So I guess I wanted to tie this conversation a little bit to what we've been talking about all day, which is how the public receives information from the court. Because journalists are mediating, professors are mediating. So I think the ACA litigation is very interesting because, as Linda pointed out, at the beginning of this, 90% of the professors said this is nuts. Not going to be one vote on the Commerce Clause issue. And then when the case comes down, the story that the professors are now telling their books being written about this is this off-the-wall to on-the-wall transition, so something happened. And then as I listen to the journalists, at least on this end of the table, same sense, this is crazy, outcome dictated by precedent. And what happened? 4 justices voted the law, 5 justices voted politics. It seems to me that there's a somewhat different explanation. One is that the professors, the 90% of them, most of whom voted for Obama in the first place, and the journalists were just dead wrong at the outset. Dead wrong with respect to their analytical skills, their predictive skills. I mean, I looked at this case at the beginning, and I thought, yeah, this is not so clear-cut. It's certainly not governed by race. It's not governed by any of the Commerce Clause cases. Justice Scalia would have no problem, as any competent lawyer, distinguishing race and other precedents from this particular statute, which was unprecedented. So I guess why rather these sort of self-serving accounts at the end, sort of explanation of what happened? The real story is not how is it that these professors and the journalists on whom the general public relies to get accurate information about what the Supreme Court is doing. How is it that they were just so wrong about this? How is it they botched this case?
I always thought it would be a close vote. Anything I said today, I always wrote about it and thought about it be a close vote. I thought that there was a very strong view on the right that it's unprecedented to mandate someone to buy a product. I remember writing people at Cato saying that early on, and it was the kind of argument I think a lot of people could say. It's fine to regulate commerce. It's another thing to make people buy. I always thought it would be a close vote. But somebody else should comment on that.
Yeah, well.
I have a question kind of related to that, which is when you're thinking about a case like that where the politics loom so large and there may be a dispute about what is law and what is politics, do you feel any obligation to the court itself as an institution to portray it? I think, David, you said your editors thought, oh, it's just going to be politics, let's not even bother talking about the Commerce Clause jurisprudence. But do you feel an obligation to the court itself to provide sort of the this is law angle?
Well, just speaking for myself, and I'll let other people talk, and then I guess we have to wrap it up, but I don't think the obligation is to the court, but I think it's to the readers. You know, even if editors think otherwise, you know, the obligation is to make the readers as well informed as possible.
Well, I wrote a lot of different stories on this over the years, and I did write some saying that there's a whole lot of Commerce Clause precedent, 1930s on, if it's economic, Congress can regulate it. But I always wrote over and over again what the challengers were saying, and saying this is a different matter. First of all, the Constitution limits the power of Congress, and you can regulate commerce, you can't force people into. So I always tried to say, here's the argument on this side, there's a lot of precedent on the other side. I didn't have a strong instinct how the court would come out. I wrote so many different stories on that, I think I could be accused of either misleading people relentlessly or covering all the different bases.
And you know, regarding when we talked a lot about the twists and turns of the case, and you didn't always know what was coming, I agree with Linda that the obligation is to the reader and not the court, but bringing the politics and all the other parts together, even for someone like me who's writing for lawyers and litigators, sometimes you have to push back against your editor. I mean, the pushback that I had once the decision came out was, you know what, instead of doing the predictable, okay, what, now that the law has been upheld, what you need to do now case, something really interesting happened here, and that was legacy building on the part of the Chief Justice with this opinion. That was really unbelievable. And I think even though we have this limited audience, they all appreciate that, and we need to cover that. That's the story on this first day. So, I mean, it is to your, you know, sort of as the person that's in there, sometimes you do have to push back against what your editors want, what people are expecting, calling and predicting and really pushing for the story that you think is right.
Okay, well, thanks to everybody.